Extradition is the surrender of a person by one state to another, the person being either accused of a crime in the requesting state or unlawfully at large after conviction. This is a considerable intrusion in the liberty of the person concerned, but one which is justified by the common interest of states in combating crimes and expunging safe havens for fugitives. The standard term being extradition. Terms such as surrender or transfer are sometimes used, often with a view to signal a substantive difference. Extradition is normally subject to strict requirements. The principle of double criminality and the rule of specialty apply, and the offences must also be extraditable. The requested state may deny extradition with reference to ne bis in idem, which sometimes also covers a pardon or an amnesty in that state, or a third state. Many states insist on reciprocity and require an international agreement for extradition. Apart from numerous bilateral agreements, the basic multilateral treaty in Europe is the 1957 European Extradition Convention and its additional protocols, adopted by the Council of Europe, which represent a traditional scheme. Global penal law conventions and anti-terrorism conventions include provisions on extradition. A common provision is that states, which make extradition conditional on the existence of a treaty, may accept the convention as the legal basis for such cooperation. The extradition procedures follow the law and practice of the requested state and applicable extradition agreements. Traditionally, the requesting state requests the arrest and extradition, or provisional arrest to be followed within a certain time by a surrender request, of the accused or convicted person. The requested state institutes proceedings to execute the request. In most states, both the executive and the judiciary have a role to play in the proceedings. A court considers the formal requirements, and the actual surrender is an executive decision. The European arrest warrant, on the other hand, is to be recognized and enforced as such in the other member states with minimal formalities. This scheme is also an example of a general trend towards a primarily judicial process. Extradition is normally restricted to serious offences, often by reference to a minimum level of punishment, which might simplify, but does not do away with, a double criminality requirement. Certain classes of offences are typically excluded from extradition. Most agreements, and thus domestic legislation, provide, as the main rule, that offences of a political nature are non-extraditable. The requested state avoids getting involved in conflicts abroad and preserves its right to grant political asylum. What will be considered a political offence is not internationally defined, however, which leaves room for considerable discretion. Another, often excluded, group of offences is military offences. These are offences according to military law, but not ordinary criminal law, and should not hinder extradition for international crimes such as war crimes. Fiscal offences are also traditionally exempt from extradition. Many states, primarily civil law jurisdictions, prohibit the extradition of their own nationals. The principle is based on a historical duty of the state to protect its citizens, sovereignty, and indeed distrust in foreign legal systems, and it is often constitutionally protected. As a counterweight, many of these states provide for extensive criminal jurisdiction over offences committed abroad. Many states that have abolished capital punishment domestically also prohibit extradition when the fugitive may face the death penalty, unless the requesting state undertakes not to impose this penalty in the case at hand, or at least not to enforce it. Some international treaties also enshrine this extradition condition. But the penalty, as such, is not banned under customary international law. In order to observe all the conditions for extradition, and often as part of the rule of specialty, the requesting state is generally not allowed to re-extradite the fugitive to a third state without the consent of the requested state. This is provided, for example, in the 1957 European Extradition Convention concerning re-extradition for offences committed before the surrender to the requesting state. When there are no extradition arrangements, or these are inapplicable or seen as ineffective, some states will resort to other measures in order to apprehend the fugitive abduction or to regular rendition. This may be conducted in a particular case, such as the Eichmann case, or even as a state policy for certain cases, such as the United States Anti-Terrorist Rendition Program. Such activities can, but do not have to, violate international law, depending on whether the territorial sovereignty of another state and the human rights of the individual concerned are respected or not. Additionally, international humanitarian law may also be invoked in case of an armed conflict.